SwayamPrabha. Digital India. Educated India.
I am Dr. Surendra Mehra, Law Department, Banaras Hindu University, Varanasi. So, this is my third lecture on res judicata, section 11 of CPC. So, this is very interesting topic because what I have seen, like students are very much enthusiastic and they are very much curious about this topic, and sometimes they face problem also relating to this topic. What is res judicata, what is res sub judice, section 10 and section 11. So, today I will talk about this res judicata, section 11 of CPC. So, as per the meaning, I mean res means, this is first slide, res means thing and judicata means decided or adjudicated. It means the thing what has already been, or the matter what has already been decided. There is a relevance or importance of this topic. So, before going through, I mean language of this section 11, first of all I will relate it with the importance of this topic. There are three principles. What is the why we kept this principle res judicata in CPC, section 11 of CPC, why we have kept in CPC. So, with these three principles you will understand more about this res judicata, you will come to know what is res judicata, then this res judicata would be very much easiest for you, even res sub judice also, section 10 also. So, first principle is no man should be vexed twice for the same cause of action. This is first principle, no man should be vexed twice for the same cause of action. It means what has already been decided, because this section 11 is basically comparing two suit, former and subsequently instituted suit. Former and subsequently instituted. It means there are two matters. One, what has already been decided, filed and decided, and second one is subsequently filing. So, whether these two suits should run together, this is just to avoid this double suit, or just to avoid this plurality of suits. This principle we have kept in CPC, section 11. So, first is no man should be vexed twice for the same cause. No man should be vexed. Can you disturb the same person for same cause of action twice or two times when matter has already been decided? So, I do not think so there should be subsequent matter. So, that is the reason we talk about section 11 bars the trial, section 10 stay the subsequent suit. Stay the subsequent, this is the difference between section 10 and 11. Section 10 stay the suit and section 11 bars the trial. It means if matter has already been decided and if you bring this thing before the court, then second matter court would not proceed with the second trial, because there can be no man should be vexed twice, no man should be disturbed twice for the same cause. If matter has already been decided, then what is the relevance of subsequent suit? What is the relevance of second suit? And second one is, it is also in the interest of state that there should be an end to a litigation. This is second public policy principle. Interest of state. What is the interest of state? What do you think? What is the interest of state? Because state is also directly affected by this one. If you file again and again the suit, what matter has already been decided, but again if you file, then this would become the problem of the state government, because for this we need number of courts, number of judges, appointment of judges, infrastructure. So, this would directly affect our fund as well as money as well as time. So, that is the reason we are calling this is in the interest of state that there should be end to a litigation. मुकदमेबाजी का अंत होना चाहिए. There should be an end to a litigation. If matter has already been decided, then and public policy principle. That's the reason we are calling it public policy principle, public policy, because state is directly, and state is just based out of or on the basis of your money, what is being collected as a tax money. So, you can spend it on other developmental work, But if you file again and again the suit what has already been decided, then again there would be a problem. There will be no development, there will be no progress, there will be no efficiency of economics will be increased. So, all these things are connected with the second one. And third one, a judicial decision must be accepted as correct one. This is also important thing, judicial decision must be accepted as correct one. If matter has already been decided and if you file, I mean suppose this principle would not been there, then if you file second suit or second matter, subsequent matter, then it means you are not accepting the authority of the court. You have doubt on judge. If the matter has already been heard and finally decided by a competent court, although there are conditions, on that basis you will apply section 11 of CPC, that is res judicata. So, judicial decision must be accepted as correct one. If you have any doubt, if you have any problem, if you are not satisfied, then you can approach the appellate court, you can go in, I mean you can get review of your matter, you can go in revision also, and appeals are already there, first appeal, second appeal and appeal to Supreme Court. But otherwise if you are satisfied, then there should not be, you cannot cheat the court, no, you cannot conceal this fact from the court. If your matter has already been decided, because basically this is again I am repeating, this is comparing, section 11 is comparing between former and subsequent suit. If your matter has already been decided, then there would not be subsequent suit, and this suit, this section 11 is based on these three principles. Keep it, collectively read it. No man should be vexed twice for the same cause of action. If the cause of action is different, then that is a different thing. You can file, nobody will stop you, because this is your inherent right. If the cause of action is different one, then there is no problem. If there is no decision on any issue, then also you can file. There is no problem. Court will not stop you, or section 11 will not be applicable, res judicata will not be applicable. But if the cause of action is same one and the cause of action has been appreciated and entertained by the court properly, then there is question, then you cannot go with subsequent suit, then you cannot go with second matter or subsequent matter. And second, again interest of state as well as judicial decision must be accepted as correct one. In simple words, where there has been an executable judgment between two parties, the rule of res judicata will ensure no fresh suit is filed between them for same relief. So, there are objective also apart from these two principles, to prevent a new decision or to prevent the same person being harassed again and again in various proceeding upon the same question. Because if you file subsequent suit, then you file, because if you have money you can file being a plaintiff. But think about the defendant, opposite party, think about the witness. If you file and if you get it submitted, I mean if you get it accepted your matter by the court, then court will issue notice or summon to the opposite party, then opposite party or defendant will come. This will again disturb him, this will again a loss of money for him, again a loss of time and money for witnesses also. So, think about them, this will harass the opposite party also. It is not a question of your own interest, it is a question because opposite party matter has already been decided between the two same parties. But if you are not satisfied, or if you are saying no, let conceal this fact and let file again this one matter, one before this court and second before another court. So, then this would be again a cheating, and this would not be applicable, and res judicata will be applied there. So, this is the thing what you have to understand. So, again I am coming on my previous slide. So, res judicata, now relate this res judicata with the three principles what I told you. Res judicata means thing decided, adjudicated, it means matter what has already been decided. There are conditions for this one. Now see this one, no court shall try any suit or issue. This is again suit or any issue. If issue is also, because there can be number of issues. So far as suit is concerned, you understand this is I am talking about one matter, I am talking about one suit. But issues, there can be number of issues in one suit, 4 issues, 5 issues, depends upon the cause of action. I normally give example like for this is basically for first year student, first year and second year student, those who haven't studied CPC, those who haven't studied substantive law, how there can be number of issues in one matter. Take example like suppose there is a matter suit for recovery of possession of immovable property. This is the matter, suppose, title of your case. Then there can be number of issues, because the matter is, title of your matter is suit for recovery of possession of, suit for recovery of possession of immovable property. Ki who is in possession, question number 1, yeah, issue number 1 you can say. Second one, since how long he is in possession. Third one, whether possession was peaceful or not. All these things. So there can be number of issues in one matter, depends upon suit for recovery of money or in any other matter. Take example of matrimonial matters also. Suppose under section 13 of Hindu Marriage Act, suppose there is a divorce petition. When marriage was, solemnized, suppose, the party is asking relief on the basis of cruelty. When party was realized, this is first issue, this can be first issue. Second, whether the cruelty is mental or physical one, whether really there was a cruelty or not. So this kind of issues, question number 1, issue number 1, issue number 2, issue number 3. There can be number of issues, issue number 1, issue number 2, issue number 3. And that issues are decided as per order 14 of CPC, framing of issues. And issues means what is based on your pleading. Pleading, what you plead through your plaint. Issues are decided on the basis of, pleading, plaint and written statement, both. Plaintiff will raise and definitely defendant will oppose. On that basis, after going through plaint and written statement, court frames issues. Court frames issues and take the signature of the concerned parties. Okay, if you are ready with these issues, or because you people can raise number of things, but ultimately court will decide whether this is relevant issue or not, this is issue or not, or you can call it fact in issue also, because otherwise rest of the things are fact as per Evidence Act. If you have studied fact, everything is fact, but court is concerned only, and fact means cause of action, and fact in issue means court is concerned only with the fact in issue. Ki okay, this is in issue, this is the point of controversy, this is the point what the court has to determine or what the court has to decide, that is called issue. And court invite evidence on those issues only. Court is not concerned with your entire cause of action, court is not concerned with entire fact. Out of those fact, out of that cause of action, court will frame certain issues, court will keep certain questions before the court, and on which the court demands list of witnesses and the statement evidence, direct and indirect evidence, both. So that's the reason I am telling you what is issue, because this question is very relevant one, pertinent one here. What is? No court shall try any suit or issue. If the court has decided any suit, then also there is no question of second suit. If the court has decided any issue, you cannot say subsequently, no, sir, only one issue was decided in that case. So because this is subsequent suit and rest of the 4 issues were not decided in first case, so let me take again all the 5 issues again. Because your first issue has already been decided, then the same issue cannot be taken up by the court in your subsequent matter, in your subsequent case. If you file, the subsequent matter would be on different issues, then that's a different thing. So no court shall try any suit or issue in which the matter directly and substantially in issue. I'll clear the meaning. I have specifically written the meaning of these words: directly, substantially in issue, and apart from it same parties, same title, finally decided, and apart from it collaterally decided, actually decided. I have kept all those meanings just for your understanding, because this is the thing by which you can understand res judicata, because these are the essential conditions, ki directly and substantially in issue. What is that issue? What are the, who are the same parties? What is the same title? What is the finally decided? So in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim, litigating under the same title in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised has been heard and finally decided by such court. So former suit, just first explanation of this one. Former suit shall denote a suit which has been decided prior to a suit in question, whether or not it was instituted prior thereto. former suit has no relevance of with the institution of suit, whether it was instituted prior or not, that is different thing. What has already been decided, that is called former suit. We are comparing former and subsequently instituted suit. So, what has already been decided, whether it was filed prior, I mean in first or not, that is a different, that is not the question here. The question is ki whether it was decided first or not, that would, if the it has been, question has been decided first, that would become your former suit. So, these are few, I mean further explanations, further explanation you can go through, there are 8 explanations mainly. So, first and fourth explanation is also related, otherwise all 8 are relevant, but I will just focus on few things which are really important. Fourth explanation is also talking about constructive, this constructive res judicata. Constructive res judicata. So, let me clear first of all this one, these conditions, then I will one by one I come on explanation also. There are 5 points mainly. The first one is the matter directly and substantially in issue in the subsequent suit must be the same matter in the subsequent suit, must be the same matter which was directly and substantially in issue either actually or constructively in the former suit. For this you can read out this explanation and this explanation also. So, let me show you few more things, then you will, and these are all conditions basically. I have just mentioned it for the purpose of this PPT. This is first condition, this is second one, the former suit must have been a suit between the same parties or between parties under whom they or any of them claim, where person litigate bona fide in respect of a public right or private right claimed in common for themselves and other, all person interested in such right shall for the purpose of this section be deemed to claim under the person so litigated. So, these are just conditions. I will clear the meaning of this condition further in further my slides, you will come to know all these things. Third one, party must have been litigated under the same title in former suit. Fourth one, court must be competent to try both former and subsequent suit. Fifth one, directly and substantially in the subsequent suit must have been heard and finally decided. So, see this one, this is the chart, you can how you can come to know matter in issue. The first one is matter in issue can be divided into 2 parts, matter directly and substantially in issue. Rest of the things, because just try to understand the meaning of this res judicata. Otherwise, there are few things like if you go just literally by explanations or literally by the language of this section 11, then really this becomes difficult for first year and second year students. So, that is the reason I framed this chart ki okay, just try to understand it in this simple language. The first one is ki matter in issue, because it is a question of matter in issue, directly and substantially in issue between former and subsequent suit. Basically, we are comparing 2 suits, former suit and subsequent suit. So, first one is matter directly and substantially in issue, second is collateral or incidentally in issue. This matter in issue can be divided in 2 parts, matter in issue, and further directly and substantially can be divided actually in issue and constructive in issue. If you understand this one, then I will clear the meaning of this one in my next slide. I have kept the meaning. See this one, matter in issue, because basically we are concerned with the issues or with the matter. Issues can be of 2 kinds, issues of fact and issues of law. Issues of law, issues of fact and issues of law. This is the first condition, guys, keep this thing in mind. I am talking about directly and substantially in issue. So, that is the reason question of issue comes in picture here. That is the reason I am telling you what is the meaning of issue, what kind of issues can be there, because we are talking about first condition of section 11, that is res judicata, directly and substantially in issue. I am again focusing on this one, emphasizing this point, directly and substantially in issue. So, that is the reason question of issues, because court is concerned with the fact in issue. Court is not concerned, because out of fact you come with fact in issue. Now, this question also becomes sometimes relevant ki what is fact and what is fact in issue. In Evidence Act, if you have studied, fact means anything as per section 3 of your Evidence Act. Fact means anything, state of thing, relation of thing capable of being perceived by any 5 senses or any mental condition of which any person is conscious. This means everything around us is fact. So, whatever the pleading is with you, whatever you are pleading, that is also fact. Is court concerned with that? Court is concerned only with the fact in issue. Out of that fact, court is pointing out, court is pointing out ki, okay, this is the point of controversy between you, between the parties. So that's the reason I am telling you ki issues can be, matter in issue means issue can be of two kinds, issues of fact, there can be issues of fact and there can be issues of law. Because you have to relate it with the condition 1, directly and substantially in issue. That's the reason I am again telling you, I am telling you the meaning of issue. Without understanding, you cannot come to know the first condition directly and substantially, because you cannot just compare ki, okay, this is former suit, this is subsequent suit. If you do not understand directly and substantially in issue, if you directly and substantially also with the meaning, you will come to know ki directly this is the meaning of direct and this is the meaning of substantive issue. But if you do not understand issue, then again there will be a problem for you. So that's the reason I am telling you, matter in issue means ki what is the point of controversy, what is the point what the court has to determine, whether that is direct or substantive, whether that is collateral or incidental. So that's the reason issue. The first thing is issue, issues of fact. Everything whatever you are writing, that is issues of fact, and out of that court is pointing out, okay, this is issues of fact. And issues of law, like in order 14 itself, rule 1 and clause 2 talking about order 14 and rule 1 clause 2 of talking about the kinds of issues of fact and issues of law. If there is a this difference is issues of this dispute is there, both kind of issues are coming in the same pleading, then court will decide first of all issues of law. Court will decide this first. And example of this one is jurisdiction related issues, whether the court has jurisdiction or not, or the matter is specifically barred by any specific statute. So if this kind of thing is, this kind of issue is there, court would decide this first, and then court would come on your issues of fact. So this is one thing, issues can be of two kind. Now see the meaning of directly. Directly means directly at once, when you see both suit, this is former suit or this is your first suit and this is your second suit, you are comparing two suit basically. So direct, there should not be, I mean the issue must not be direct and substantive one. The issue between both the suits or in both the suit must not be direct one. Direct means at once, immediately, without any intervention, just by reading plaint. If you come to no, the matter is same one, the suit for recovery of money, same thing. Suit for partition, same thing. If the court is coming to know this one, then what does it mean? You are claiming, it means you are disturbing the same person for the same cause of action. Can you disturb it? Again, this would be a violation of this principle. First principle, what I told you in beginning, no man should be vexed twice for the same cause of action. It is in the interest of state that there should be an end to a litigation, or judicial decision must be accepted as correct one. So when the moment you compare both the suits, two matter, and you come to no, the matter is direct one, there is no question of interpretation, no need to go through it. Just out of this, I mean on the surface itself, if you come to know patent one, you know the matter is same one, direct one. Or substantially means essentially, materially, or in substantial manner. Sometimes it appears on the face ki no, the matter is, if you compare two matters, sometimes it appears ki no, the matter is different one. Both the matters are different one, no, section 11 should not be applicable here. But if the moment you go into detail of this case, then you will come to know ki substantially the matter is same one. The demand is of same thing. So then again, this is called the meaning of substantive. Substantially in issue, directly in issue. Are you getting my point, what I am trying to tell you? You are guys comparing two things, two matter, first suit and second suit. If your first matter has already been decided on merit by a competent court, then there should not be second suit, subsequent suit you can call it, because no man should be vexed twice for the same cause of action. You cannot disturb, you cannot harass the same person for the same cause of action, because this would become otherwise this would become a mockery of justice. People will, I mean, decide it, court decides first matter and then subsequently also if you file another matter on the basis of same cause of action, so this would become, I mean there would be a mockery of justice. What would be the importance of then judges or court? Authority, because they have, I mean they have authority, whatever they are deciding, and if the thing is based on merit, or again the thing is whether the thing is based on merit or not, you people are raising the point, you people are putting the evidence or bringing the evidence before the court, and court is applying his its mind, judicial mind. Then subsequently you cannot say that no, this court has wrongly decided. If you have grievance, you can approach the appellate court, but you should accept, you should give due respect to the court. You should accept the decision of the court as correct one. You cannot disturb the person for the same cause of action. Article 20 of your constitution, I think clause 2 of your constitution is also talking about it. No one can be vexed twice for the same cause of action. No one should be prosecuted for the same cause of action. In CRPC also, I think in general principles article, section 300 also talking about it. So you should keep all these things in your mind. So substantially means essentially, materially or substantial manner, and actually in issue. Next point, because if you see this diagram, then you can come to know that directly and substantially can be divided into two parts, because this is also important thing. Sometimes this direct and substantially also becomes little bit confusing one. So actually in issue, actually see this one, actually in issue means when it has alleged by one party, denied or admitted by the other. Alleged by one party and denied or admitted by the other, because if you are alleging through your plaint, court is also accepting, and the opposite, on the basis of also court is issuing notice or summon to the opposite party, and opposite party is coming either accepting or admitting or denying. These are the two choices lies with the opposite party. So if these two things are there, you are alleging and opposite party is either admitting or rejecting, that is called actually in issue. Otherwise, after framing issues, that is the reason I was telling you, I have given the reference of order 14 of CPC. Court frames issues on the basis of your pleading, on the basis of your plaint and written statement. See this thing very clearly, you have to understand this one. Court frames issues on the basis of your plaint and written statement, and then courts will show you, okay, these are the point of controversy, Mr. Advocate, between you and your opposite party. Then you have to find out whether these are the really issues or not, whether these are the really framed issues or not. If you have any objection, raise those objections before the court. No, your lordship, this is not the point of controversy, this is not the point of determination between us. Then court will correct it further, court will frame new issue, or court will amend that issue depending upon your objection. If you are not objecting, then court will take signature and court will invite evidence. List of witnesses, then evidence. So this is the thing. Actually in issue means when it alleged by one party and denied or admitted. So this is one thing, apart from directly and substantially in issue. Collateral or incidental, there can be this kind of issue also can be there in your matter. Collateral or incidental issue means an issue which is ancillary to the direct issue, in respect of which no relief is claimed. No relief. This comes automatically, because in one plaint you write almost everything, whatever the cause of action, whatever the violation of your right is there, you try to write everything just to make understand the court, your lordship, actually this is the basic, or this is the base of my claim. Whether that is material or not, that is important or not, but just to, for the sake of your convenience, for the sake of your benefit, no, court will understand this one, no, this was the history, okay, on this day he took this money and this was the purpose of why he took money from me, and now he is not denying, and in between also he promised this much time and he also given this much money to me back, and all those things. It means you, although the issue is something else, this opposite party is not giving money to you, but you, just to make understand the court, you write everything almost. That is the reason plaint becomes lengthy one, 10 page, 20 page, 30 page or 40 page, you try to write almost everything. So this is what I am saying, collateral or incidental. So these issues are called collateral or incidental issue, which comes by incident, but you are not claiming any relief, but you are keeping in plaint just to make understand the court ki, okay, just to get the order in your favor, you mention all those things in your plaint. Collateral or incidental issue, in respect of which no relief is claimed, you do not claim anything specifically. So, this is what I am trying to tell you, because we are comparing two suit, former suit and subsequent suit, and former suit means ki what has already been decided, there is no question of institution of suit, what has already been decided, that is for some subsequent suit can be decided further. So, that would become former suit. So, basically I am again taking you back there ki this first condition I am relating it with this one, the matter directly and substantially in issue in the subsequent suit must be the same matter which was directly and substantially in issue. So, this is the first condition, I am just telling you ki how the question of issue comes here in picture, why the question of issue becomes relevant for you. If you do not understand issue, then you cannot understand the first condition of res judicata, that is directly and substantially in issue, that is collateral or incidental in issue, that is actually and constructively in issue. So, this is first condition, matter directly. Now, apart from it also there are further explanation of this one, matter directly and substantially. A matter cannot be said to have been directly and substantially in issue in a suit unless it was alleged by one party and denied or admitted either expressly or by necessary implication by the other party. See this one, every suit involves matter for which relief is claimed, and such matters are necessarily matter which are directly and substantially in issue. However, some matters are also there for which relief is not claimed. Again the explanation of the same thing what I have told you already, but they are brought in issue to help decide the matter for which relief is claimed. This is collateral issue or incidental issue. Just to decide the matter, you write or you mention in your pleadings, okay, this is the basics of your problem, this is the base or this is the history of your case, how the opposite party has violated your right. So, these matters are collateral or incidental in issue. So, this is first thing, matter directly and substantial issue. I hope you understood this one, matter directly and substantially in issue. We are comparing again, I am telling you, res judicata is basically upon the subsequent suit, related with those same condition ki no man should be vexed twice for the same cause. If this condition would not have been there, then there would be no end of litigation. You people will harass the same party on the basis of same cause of action again and again. This is civil matter. In criminal matter, the chances are something different, because police will investigate the matter. If in case of criminal matter, police will investigate the matter. Otherwise, police will not lodge FIR. Police will prepare the police report and then charge sheet. So, that is the reason there is a restriction, there is a filtration of police. But in civil matter, there is no objection, because right to suit is your inherent right on the basis of cause of action, on the basis of if your court fees and all those things, valuation, you can file and nobody will stop you. But this filtration is there, filtration of section 10 and section 11. Section 10 is talking about res sub judice. If the matter is pending, then you cannot file another suit if your matter is pending. Section 11 is talking, if the matter has already been decided, then there would be no second suit. If the matter is already been decided on merit, then there would be no second suit. So, this kind of bar or this kind of filtration is there. This is a check on your second suit. Otherwise, you people will harass the party, court will become overburdened, and this will again a loss to the state government or state, and again would be a mockery of justice, because you people, it means you people are not accepting the judicial decision as correct one. So, this is the thing. These are the few illustrations. A sues B for the rent of certain land for the year 2023. B defense is that ki no rent is due. Here the claim for rent is a matter in respect of which relief is claimed. See this one, these are very easy illustrations. It is therefore a matter which is directly and substantially in issue. It means matter of rent. Matter of rent is direct and substantially, you can easily come to know. Second, A sues B for a declaration of title to certain lands and for the rent of those land for the year 2023. B denies A's title to the land and contends that no rent is due. In this case, there are two matters. One is of title, another one is no rent is due, in respect of which relief is claimed. The title to the lands and the claim, these are the two matters. These are the two matters. This is what you have to understand, the title to the land and the claim for rent. Both these matters are directly and substantially. You can easily, one is easily coming to know this one. just for there can be two matters also in one case, there can be two issue also in one case. A sues for B for rent, B pleads that lesser rent is payable because the actual area of the land is lesser than what is mentioned in the lease deed. The court however finds that the actual area is greater than the one shown in the lease. This finding as to excess area, see this one, the pleading was of lesser area and the finding is the area is excess area, and on excess area the res judicata is not res judicata because the issue was only collectively or incidentally in issue. Got my point? So, this is what you have to understand. Now, the second condition, that is same parties. Same parties, this is also very important ki what is, who is same parties, what is same parties. Judgment and decree binds only the parties and previes, that is those who claim under a party, who claim under a suit or party, who are parties basically. If the parties are different, then there is no res judicata, then there is no res judicata. So, see this one ki who is same party? A party is person whose name appears on the records at the time of decision, whose name appears on the record ki this is plaintiff, this is defendant, this is co-plaintiff, this is co-defendant, whose name appears on the record at the time of decision. Otherwise, if the party is a question of non-joinder or misjoinder or striked out parties or discharge from the party, order 1 rule 9 and 10 of CPC, order 1 rule 9 and rule 10 of CPC. This is, you can relate it with this one, because if your name is appearing on the record, then you are the same parties at the time, but because in beginning you can get it striked off also, you can get discharged also if you file this application under order 1 rule 9 and 10 ki misjoinder, it is a question of misjoinder, it is question of non-joinder. So, all those things are there. So, that it means the parties are not same one. If the parties are there at the time of decision, because before the decision you can file application and you can get it striked off, or depending upon if it is a question of misjoinder and non-joinder. I hope you will understand if you study order 1 and rule 9 and 10. There is one example also, you will understand. A sues B for rent, B contends that C and not A is the landlord. A fails to prove his title and the suit is dismissed. A then sues B and C for a declaration of his title to the property. The suit is not barred, for the party to the two suits are not the same one. If the parties are not same one, then there is no question of res judicata. Matter can be same one, direct one, but if the parties are different one, then there is no question of res judicata. So, collectively you have to study these 5 conditions and apply these 5 conditions directly and substantially in issue, matter in issue, then same parties, same title, then competent court, and then finally heard case or not. Collectively you have to apply these 5 conditions. Litigating under the same title, this is also very important word, same title. Same title means the demand should be of the same quality in the second suit as was in the first suit. Demand, it is a question of demand, same title. Title refers to the capacity or interest of a party, and it has nothing to do with the particular cause of action on which he sues or is sued. Particular cause of action is not the criteria of same title. Particular cause or same cause of action is not the criteria. Criteria is ki whether the demand is of the same quality or not. So, on the basis of demand, what you are claiming in your plaint or through your plaint, that will decide ki matter is same title, or based on the matter is based on same title or not. Demand, keep this thing in your mind, demand should be of the same quality. It has nothing to do with the particular cause of action, because there can be same cause of action, but if the demand is something else, in one suit you demanded something else and in another suit you are demanding something else. Sometimes this can happen, you can forget ki no, in first my pleading I couldn't raise this issue, or this issue was not at that time. After due diligence, applying your due diligence, the thing was not in your mind, or the previous issue, although the cause of action is same one, but the previous issue, suppose take example of your rented property. Earlier, I mean, you filed first suit on the same cause of action on the basis of same property. No, my rent is due, and suppose this matter has been decided by the court. Then next month also your tenant is not paying suppose rent to you. Then again you will file suit. No, now this is the second month rent, and that what has already been decided. This was the first month rent. So on this basis, you should understand cause of action is same in these both two cases. The same property, the same immovable property, rented property, but earlier the demand was of first month rent, and now the demand is of second month rent. So this is on this basis you should understand what is the meaning of demand. Demand should be of the same quality. It has nothing to do with the same cause of action. So this is one thing, and I have mentioned test also. What test you have to apply just to understand this same title. And now fourth point, that is competent court. A decision to operate as res judicata must be the decision of competent court. This is also one thing you have to understand. Competent court, because a decree passed by a court without jurisdiction, without competency is null and void, because jurisdiction and competency both are the almost same thing. So court must be competent one. What has been decided, or I mean who has decided your first case, whether the court was competent one or not, that is also equally important. You cannot say this thing, no, earlier the court was, I mean, competent one, or now the court is not competent one. Like take this is one. Therefore, a judgment delivered by a court not competent to deliver it cannot operate as res judicata. Cannot operate as res judicata. This section 11 will not be applicable if your court was not competent one, because validity can be challenged at any stage, even in execution, in collateral proceeding. So this is also you have to ensure this one, whether the decision was by a competent court or not. And for this one, this purpose, there are three kind of jurisdiction: court of exclusive jurisdiction, court of concurrent jurisdiction, court of limited jurisdiction. I have given the examples also. What is court of exclusive? It means sole, concurrent simultaneously when two courts have jurisdiction, and limited again the same court is limited jurisdiction. So on this basis you can decide I mean how your matter was decided, whether the court was competent one or not, just for your understanding. So this is about competent court. And now the fifth one is heard and finally decided. This is very important, again very important condition. A matter can be said to have been heard and finally decided in spite of the fact that the former suit was disposed of ex parte by dismissal of failure to produce his evidence or to perform certain act, and all these things are there. So just to understand whether matter is heard, because hearing is not something just listening your argument, whether court has given you full space, whether court has given you full opportunity, whether court has appreciated your evidence, appreciated your argument, appreciated your objection, given you, served you notice or someone or not. So only then you can say no, heard and finally decided. This is there is a meaning of this one, heard. If court is not hearing you, or court is rejecting your objection, overruling your objection, then will you say this is, I mean, court has heard you fully? No, you will not say this thing. So because you are comparing two suit, first suit and second suit, res judicata we are talking about 11, former suit and subsequent we are talking about. So heard and finally decided. If your first matter, or the matter what has already been decided, the former matter has been heard and finally decided, then there would be no subsequent suit. I have given you few things here. What does it mean, heard and finally decided? Like want of jurisdiction. If the court had no jurisdiction, then what is the meaning of heard? Court will not give you opportunity, and court has no power because court has no jurisdiction. So you will not say this thing, I mean, without jurisdiction, if you are saying something before one court and you are saying no, court has heard you, there is no meaning of this one. Want of jurisdiction, it means whether the court has jurisdiction or not, court is lacking that jurisdiction, then there is no question of hearing before that, or there is no question of arguing before that court. Second one is, I mean this one, failure of furnish security for cost, for default on account of plaintiff appearance, for failure on the part of the plaintiff to produce probate, this is relating to will, for want of cause of action. If there is no cause of action, and without this, if you are arguing, or if you suppose you get ex parte decree, or want of notice, without notice, Notice must be, this is also principle of natural justice, odi altum partem, opportunity of hearing, want of notice, that ensure this one, want of notice on the ground of non-joinder or misjoinder of parties. So, all these issues makes you, I mean, if you understand all these issues, then you can say your matter has been heard and finally decided by the court. Otherwise, there would be no applicability of res judicata, guys, on your subsequent suit. You are comparing two suit, former suit and subsequent suit. What has already been decided and subsequent suit means, if matter has already been decided, then you cannot file subsequent suit. This will bar the trial of your second suit. If you plead and if the court accept it, no matter has already been heard by a competent court, if the title was same one, if the parties were same one, if the matter was directly and substantially is, same one between, in both the suits, then if these things are there, then court will not, or court should not, must not accept your subsequent suit. Constructive res judicata, this is relating to explanation 4. This is also very important sometimes, and you can understand it with the state of UP versus Nawab Hussain case. What is constructive res judicata? Explanation 4 of your section 11. Very important. Sometimes question comes on this point also. What is constructive res judicata? It means the plea. Read this explanation 4. Any matter which might and ought to have been made ground of defense or attack in such former suit shall be deemed to have been a matter directly and substantially in issue. It means the matter which could have been, or which ought to have been made a ground of defense or attack. The thing was in your mind, but deliberately you concealed that, and now subsequently, just for the purpose of second suit, you are raising this one. So, it means court will not accept, court will apply this constructive res judicata ki no, the thing was already in your mind, this defense was already in your mind. And thus the same thing is happened in case of state of UP versus Nawab Hussain. There was an inspector, and first he filed, he was dismissed from services by IG police, DIG police. Then first he raised this point ki no, charge sheet was not submitted, given to me. Then this plea was rejected by the court. Then subsequently he said ki no, IG was the appointing authority. Then how DIG removed me from services, terminated my services. So court said ki no, these things was already in your knowledge. Now you cannot say this thing ki no, IG appointed you. Earlier you were saying ki no, charge sheet was not submitted to you or given to you. So the thing were in your mind, and deliberately you raise this just for the purpose of, or otherwise, so everybody will say, if the court allows suppose this kind of cases, then everybody will say ki no, the thing was not in my mind, or this defense was not in my mind. You cannot be innocent one, because ignorance of law is no excuse. So this is also a little bit related with this one, ki the thing was in your mind and court would accept this one, court also understand this one. So this is constructive res judicata. So here different proceeding on which res judicata is applicable or not. Section 11, how, criminal proceeding res judicata is applicable. Habeas corpus pe res judicata only on habeas corpus, otherwise res judicata is applicable on other writs, mandamus, quo warranto, habeas, this certiorari and prohibition. But on this habeas corpus writ, res judicata is not applicable, because this is habeas corpus is related with the liberty of your case. You understand this one. Dismissal of suit, ex parte decree, compromise decree, again res judicata does not apply, because again depends upon your compromise, upon your mutual consent. Ex parte passed by a competent court on merit will operate as res judicata, then this will be applicable. So all these things, these are few just easiest simple one, points where res judicata is applicable and where res judicata is not applicable. You can understand this one. And this is res judicata between co-defendant. So for this we have these conditions, must be conflict of interest between co-defendant. It must be necessary to decide this conflict in order to grant relief to the plaintiff. Question between defendant must be finally decided. Co-defendant were necessary party. So on this basis, and you can for this you can also study Sayyid Meherban Ali case. You can go through it and you can easily come to know how res judicata is applicable between co-defendant, co-plaintiff. Execution proceeding, and how this is, whether this is exhaustive one or not. So now this is the last point. This is res judicata and estoppel. Res judicata, because this is also, sometimes the difference comes. I have just covered the important things on this res judicata, the 5 elements, 5 conditions of res judicata and meaning and the importance of res judicata. And now this is also very important one, res judicata section 11 of CPC and estoppel section 115 of Evidence Act. This is little bit similar one. Res judicata, you understand ki this results from decision of court. It means if the court has decided your matter on the basis of merit by competent court, same title, same all those conditions, then there would be no second or subsequent suit. Second condition, it proceed on the ground of public policy to end litigation. This is for the purpose, this is the purpose of res judicata, to end litigation. There should be an end to a litigation. It is in the interest of state that there should be an end to a litigation, or judicial decision must be accepted as correct one. So, just to end this litigation, this difference comes normally in exams on small type of question, difference between res judicata and estoppel, that is the reason I am covering it. So, to end litigation, this is the purpose, and for that you can relate, I mean go through all those 3 principles what I have discussed in beginning, to end litigation. Third is prohibits an inquiry in beginning outs the jurisdiction of the court to try the case. I told you already that section 11 bars the trial, subsequent trial. Section 10 only stay this trial, stay, that is the reason we call it stay of suit or res sub judice, but section 11 bars the trial. If the matter is same one, if you compare, and this is the job of you parties, you advocates, you should make understand the court, no, your lordship, this is a direct and substantive matter. The matters has already been decided. Otherwise, court can also commit this mistake, court would not understand. How court would come to know, no, the matter has already been decided. This is the job of the opposite party against whom you are, I mean filing the suit. So, you should be aware, you should be aware about this one. Otherwise, court will, because you people are paying money and your people are, paying court fees. So, there is problem with that. This is your inherent right. So, fourth one, presumes conclusivity the truth of the former decision. Judicial decision must be accepted as correct one. This is the meaning of this fourth condition. Conclusivity, what the court has decided, that is conclusive one. Because court has given time, court has applied, judicial mind. Now you cannot raise any doubt on the integrity of the court. So, that is conclusive one. Court has appreciated, court has gone through your pleading and written statement and your, one by one framed issues and one by one examination and chief examination of your witnesses. Then court decide matters, then court awards decree. So, that is conclusive one. If you say something tomorrow and say, no, I mean the court has not applied mind. So, then really, this is really difficult, and this would be difficult for the court. Who will believe the temple of this justice? No doubt you can go in appeal if you are not satisfied, that is a different thing, but this is conclusive thing. Prohibits a man averring the same thing twice in successive litigation. This is averring the same thing twice in the same successive litigation, the same thing you cannot repeat. And now see this estoppel. This result from the act of the parties, because here there is a question of promise, it is a question of representation. When I represent my, my statement, when I represent something through my statement, proceeds on, I mean see this one, second one you will come to know more about it, proceeds on doctrine of equality, that he who by his own conduct has induced another. If I by my own conduct induce you, then subsequently I cannot go back from my statement. And if you are definitely, if you are altering your position on the basis of my statement, on the basis of my promise, that is estoppel. To alter his position to his advantage, cannot turn around and take advantage of such alteration. If I am saying, it means there is a relevance, there is the importance of my statement, there is the importance of my representation, there is the importance of this thing. So, whatever I am saying, that must be, okay, there can be mistakes, that is a different thing, but if I am saying something, that must be the crux or the meaning, the idea behind this one must be clear, that must be honest one. So, subsequently I cannot say, I did not say this thing. So, it is only a rule of evidence, prevents a person from setting up what he calls the truth, and prevents a person from saying one thing at one time and opposite at the another thing. It means you cannot take or you cannot say two things at two different times. If I alter my position on the basis of your representation, so you cannot go back. So, this is the difference between res judicata and estoppel, section 115 of your estoppel evidence act. So, you can relate it, and I mean both the things are almost same one, but this is one is from the decision of court and another one is act of parties, because this is talking about two person representation, the statement between two parties, and this is all about decision of the court. So, section 11 in crux, I will say again, I will take you back, I mean on those few things, these 5 conditions, this chart if you understand, and if you understand the meaning of these few words or words of conditions of these 5 conditions, adjudicated, decided, then there should not be subsequent suit, because otherwise there would be no end of litigation. Basically, the purpose of section 11 is to end the litigation. So, this is what you have to keep it in mind. Thank you. This is all about section 11.